Okay, welcome again to the continuation of the lectures on persons and family relations. So our topic for today is family home. Okay, so the basic thing that you have to learn regarding family home is what consists of a family home? What residences or homes can be considered as quote unquote a family home? Okay, what is the reason? Why is it that there is a need to know if a certain residence is a family home? What are the privileges that are attached to a family home? And who are the persons who are entitled to the said privileges of a family home? So Article 152 defines for us what a family home is. According to Article 152 of the Family Code, the family home constituted jointly by the husband and the wife or by the head of the family is the dwelling house where they and their family reside and the land on which it is situated. So the family home consists of the house and lot. Okay? And it is the place where the family resides. So, by the name itself, family home, it is the residence of the family. It does not consist only of the dwelling, which is the building, but also the land on which it stands. The family home is deemed constituted on a house and lot from the time that it is occupied as a family residence. So from the time of its constitution and so long as any of its beneficiaries actually reside therein, the family home continues to be such and is exempt from execution, forced sale, or attachment. Okay, so upon the promulgation or upon the effectivity of the family code, there is no need for judicial or extrajudicial constitution of the family home. So the moment that the family home is built and it was occupied by the family as their residence, it is already constituted as a family home. And being a family home, it enjoys or it is entitled to certain privileges such that it is exempt from execution, forced sale, or attachment. What is the reason for that? The reason for that is, again, the law takes a special interest on the family and protects it. Okay, so aside from the earnest effort requirement as discussed in the previous chapters. Okay, the family home is also the protection of the family home is also one of the benefits given by law, okay, to a family. Okay, who are the beneficiaries of a family home? Article 154 tells us that the beneficiaries of a family home are as follows: the husband and wife or an unmarried person who is the head of the family, and their parents, ascendants, descendants, brothers and sisters, whether the relationship be legitimate or illegitimate, who are living in the family home and who depend upon the head of the family for legal support. So, as long as these beneficiaries occupy, as long as any of them occupy the family home, then it remains as a family home. Okay. Now, one of the benefits of a family home is the exemption from execution, forced sale, or attachment, except as follows. Okay, so there is a requirement to be exempt from execution, forced sale, or attachment. The following requirements must first be complied with. Okay, first, uh, non-payment of taxes. So if there are taxes, real property taxes of the lot on which the family home is built, uh, the said non-payment of taxes will not exempt the family home from forced sale, execution, or attachment to satisfy the real property taxes that were not paid. Second, for debts incurred prior to the constitution of the family home. So if you have debts before the family home was constituted, then it will not also be a reason for exemption of the family home from forced sale, attachment, or execution. For debts secured by mortgages on the premises before or after such constitution. So if you have debts, okay, and the family home was mortgaged to secure the said debts, then it will not also be a ground for exemption. And lastly, for debts due to laborers, mechanics, architects, builders, material men, and others who have rendered service or furnished materials for the constitution of the building. So, if you have incurred debts to those who provided materials or those who provided service so that the family home can be built, then it will also not be a ground for exemption. Another requirement that must be satisfied for a family home to be exempt from execution or attachment is the amount, okay, of the family home. The actual value under Article 157, the actual value of the family home shall not exceed, at the time of its constitution, the amount of 300,000 pesos in urban areas and 200,000 pesos in rural areas. Okay, so if it exceeds that amount, then the family home cannot invoke that it is already it is exempt from execution for sale or attachment. Article 158, the family home may be sold, alienated, donated, assigned, or encumbered by the owner or owners thereof with the written consent of the person constituting the same, the latter spouse, and a majority of the beneficiaries of legal age. And also, regarding the continuity of the family home shall continue despite the death of one or both spouses or of the unmarried head of the family for a period of 10 years or for as long as there is a minor beneficiary and the heirs cannot partition the same unless the court finds compelling reasons therefore. So the family home continues to be a family home despite the passing away of the one who constituted the same. The only requirement is that there must be a person, a minor beneficiary, who is living in the said family, and that the same cannot be partitioned unless there is a compelling reason. Okay, Article 160. When a creditor whose claims is not among those mentioned in Article 155 obtains a judgment in his favor, and he has reasonable grounds to believe that the family home is actually worth more than the maximum amount, he may apply to the court which rendered the judgment for an order directing the sale of the property under execution. Okay? For if you want to avail of the benefits of the family home, a person may constitute or be the beneficiary of only one family home. Because there are cases wherein a family does not have only one residence. Because there may be cases when there are two or three or more, even more than three residences of a family located in different places. So you cannot avail of the benefits of a family home for more than one. Okay, so you can only be the beneficiary of only one family home. Okay, let us now go to the cases. We have the case of Salazar versus Pelias. So in this case, there is a decision in a case for recovery of ownership, ordering the Lastimosa heirs to vacate the property which is subject of the case and to surrender them to the heirs of Nivera. There is no dispute that the RTC ruling has become final and executor. Now, Felicitas wants to prevent execution. okay, on the ground that the property which is subject of execution is a family home and therefore is exempt from execution. Okay, in that case, in the Salazar case, the Supreme Court said the family home is a real right which is gratuitous, inalienable, and free from attachment, constituted over the dwelling place and the land on which it is situated. It confers upon a particular family the right to enjoy such properties. It cannot be seized by creditors except in certain special cases. However, the claim that the property is exempt from execution for being the movant's family home is not a magic one that will freeze the court's hand and forestall the execution of a final and executory ruling. It must be noted that it is not sufficient for the claimant to merely allege that such property is a family home. Whether the claim is premised under the old civil code or the family code, the claim for exception must be set up and proved. Okay, so um, it must be invoked. Okay, it must be alleged seasonably. Okay, to be exempt from execution. In addition, residence in the family home must be actual. The law explicitly mandates that the occupancy of a family home, either by the owner or by any of its beneficiaries, must be actual. So this occupancy must be real or actually existing, as opposed to something merely possible or that which is merely presumptive or constructive. So aside from the requirement of the amount of the family home, which is 300,000 in urban areas and 200,000 in rural areas. The family home to be considered as a family home must be uh, must uh, must be actually occupied by the beneficiaries thereof. If there is no actual occupancy, you cannot consider that as a family home. Felicitas, in this case, adduced no proof to substantiate her claim that the property sought to be executed is indeed her family home. Okay? The case of B2 versus Abunda. Okay, again, this involves one of the exceptions to the general rule that a family home is exempt from execution for sale or attachment because it is one which is intended as payment for the debt secured by mortgages on the premises. Since petitioner's property was voluntarily used by him as security for a loan he obtained, it may be subject to execution and attachment. So if you use the family home to obtain a loan and you mortgage the family home to secure payment of the loan, okay, then you cannot invoke the exemption of the family home from execution or sale or attachment. Okay? We have the case of Yohio versus Bell. The issue in that case is whether or not the family home of the petitioners could be the subject of a writ of execution and sold at public auction. Okay, the Supreme Court in that case said the great controlling purpose and policy of the Constitution is the protection and preservation of the homestead, the dwelling place. A houseless, homeless population is a burden upon the energy, industry, and morals of the community to which it belongs. No greater calamity not tainted with crime can befall a family than to be expelled from the roof in which it has been gathered and sheltered. The family home cannot be seized by creditors except in special cases. So in the case of Yohio versus Bell, the Supreme Court explained the reason why the family home is exempt from execution for sale or attachment. So the law protects, it is in effect a sort of a measure for the protection of the family because a uh, a family has to have a roof under their heads. Okay? So that is the very reason why it was exempted from execution for sale or attachment. Certainly, the humane considerations for which the law surrounds the family home with immunities from levy do not include the intent to enable debtors to thwart the just claim of their creditors. So they claim that the actual value of respondent's family home exceeds 300,000. This fact is supposedly shown by the deed of sale whereby the respondents agreed to sell the property for 1 million way back in 1995. So to warrant the execution sale of the family home, petitioners need to establish the following. There was an increase in its actual value. The increase resulted from voluntary improvements on the property, and the increased actual value exceeded the maximum allowed under Article 157. So if you constituted the family home and you only spent 300,000 for its construction, okay, the house and the lot does not exceed 300,000. But later on, you introduce improvements which made the value of the family home more than the threshold amount of 300,000. Then it will no longer be exempt from execution for sale or attachment. So the sole evidence, in this case, the sole evidence presented was the deed of sale, but the trial court had already determined with finality that the contract was null and that the transaction was an equitable mortgage. When petitioners and spouses bill executed the deed of sale, the price therein was not the actual value of the property in dispute. So the trial court already determined with finality that the property was a family home and there was no proof that its value had increased beyond the statutory limit due to voluntary improvements by the respondent. Yet it ordered the execution sale of the property. So there was grave abuse of discretion on the part of the trial court. Okay. Next case is Fortalesa versus Lapitan. Okay. In this case, Fortalesa argued that the property is exempt because it is a family home. So it enjoys the immunities provided under the law. So Article 155 explicitly allows the forced sale of a family home for debts secured by mortgages on the premises before or after such constitution. In this case, there is no doubt that Fortalesa voluntarily executed a deed of real estate mortgage over the property, which was even notarized. Such claim for exemption should be set up and proved to the sheriff before the sale of the property at public auction. Failure to do so would extort the party from claiming the exemption. So just like suits between members of the same family, the earnest effort requirement has to be alleged and seasonably. So that ruling is also applicable to family home. If in order to enjoy the immunities provided by law, okay, for family homes, it must be seasonably alleged. Okay, otherwise it is deemed waived. So the right of exemption is a personal privilege granted to the judgment debtor, and it must be claimed not by the sheriff, but by the debtor himself at the time of the levy or within a reasonable period thereafter. Reasonable time for purposes of the law on exemption does not mean a time after the expiration of the 1-year period for a judgment debtor to redeem the property. Okay? So, the Mesa versus Acero. The thing to be learned in the case of the Mesa versus Acero is there a need to judicially or extrajudicially constitute residents to be considered as a family home? Okay, so it would depend on the date when the family home was built. Whether is it before the effectivity of the family code, in which case the provisions of the civil code will apply, or is it the family code? Okay. The Supreme Court said the foregoing rules on constitution of family homes for purposes of exemption from execution could be summarized as follows. Family residences constructed after the effectivity of the family code, family residences constructed before the effectivity of the family code or before August 3, 1988 must be constituted as a family home, either judicially or extrajudicially, in accordance with the provisions of the Civil Code. Okay. However, if your family residence was constructed after the effectivity of the family code, they're automatically deemed to be family homes and thus exempt from execution from the time it was constituted and last as long as any of its beneficiaries reside there. So there is no more need for constitution. So once it is built and once the family resides therein, it is automatically a family home. Okay? If it was built after August 3, 1988. So what happens now with respect to family homes which were constructed before August 3, 1988, but it is still existing after the family code took effect? Okay. Family residences which were not judicially or extrajudicially constituted as a family home prior to the effectivity of the family code but were existing thereafter are considered as family homes by operation of law and are prospectively entitled to the benefits accorded to a family home under the family code. So if the residence has continued to this day and has been occupied by any of the beneficiaries of a family home, there is no more need for judicial or extrajudicial constitution. Okay, it is automatically considered as a family home. Okay, if the residence still exists after the effectivity of the family home. In the case of the Mesa, the property became a family residence sometime in January 1987. So at that time, the civil code is still the applicable law. There was no showing that the same was judicially or extrajudicially constituted. Still, when the family code took effect on August 3, 1988, the subject property became a family home by operation of law and was thus prospectively exempt from execution. It is not sufficient that the person claiming exemption merely alleges that such a property is a family home. This claim for exemption must be set up and proved to the sheriff. Again, the family home is a real right which is gratuitous, inalienable, and free from attachment. It cannot be seized by creditors except in certain special cases. However, this right can be waived or be barred by laches by the failure to set up and prove the status of the property as a family home at the time of the levy or at a reasonable time thereafter. It is undisputed that the petitioners allowed a considerable time to lapse before claiming exemption, the family home. The petitioners allowed the subject property to be levied upon and the public sale to proceed. 1 year lapse from the time the subject property was sold until a final deed of sale was issued. It was only after the respondents filed a complaint for unlawful detainer for 4 years from the time of the auction sale that the petitioners claimed the exemption of a family home. The petitioners' negligence or omission to assert their right within reasonable time gives rise to the presumption that they have abandoned, waived, or declined to assert it. So, remember, a family home is a benefit or privilege provided by law. It must be seasonably claimed. Otherwise, it can be considered waived or the immunity granted by law may be considered as barred by laches. Okay. Ramos versus Pangilinan is actually a reiteration of the previous case of the Mesa. Okay, so alleging that the Pandacan property was a family home, uh, Ramos moved to quash the writ of execution. Okay. Again, in Ramos, similar to the previous case of De Mesa, the court explained the need to constitute the family home either judicially or extrajudicially if it was built before the effectivity of the family code. Okay, after the effectivity of the family code, there is no more need. When a family home or family residence is built and the beneficiaries of the family home occupy the same, it is by operation of law considered as a family home. There is no need for judicial or extrajudicial constitution. So in this case, there being no proof that the Pandacan property was judicially or extrajudicially constituted, the law's protective mantle cannot be availed of by the petition. Okay, so that is the end of the presentation for family home. Thank you for listening.